You will die one day and you need a will to say who gets your stuff when you're gone. In today's video, I'm gonna break down how you can complete a will that is valid and enforceable and is gonna clear up any controversy of who's getting your stuff once you've passed on. I'm Matt Sorensen, let's build wealth. Now, if you're watching this and you don't even have a will, let alone a full trust and estate plan, which by the way, most of you that have 500,000 of assets or more, you need a real trust and estate plan. But if you don't have anything, at a minimum, right now, I want you to take out a piece of paper and start writing as I'm talking here, because by the end, you're gonna have a valid and binding will that's gonna clarify who gets your assets when you die. All right, now what we're talking about here is what's called a holographic will. This is essentially a handwritten will signed by the testator, the person whose estate this is, and that is legally binding. In most states, Texas, California, Arizona, most states across the US, a handwritten will that is signed by the person testating it is a valid will. Now there's some states it's not, check the description below. In those states where it's not, you have to have two witnesses. Okay, so if you're in one of those states, you need two other people who aren't named in the will as getting your stuff to be witnesses. But again, for most of you, you don't even need that. It simply needs to be in your handwriting and signed. Now, do not make this mistake. Do not start typing and print this out because you think it's gonna look nicer. That will not be valid, okay? This needs to be in your handwriting. That's the key here. If you wanna type this out, you're gonna need to go have a notary and witnesses present when you sign this thing. So this is the key here. This is a holographic handwritten will, so make sure you're not typing this out. This is in your handwriting. All right, now let's go over some basics that also have to be in the will besides it being in your handwriting. It needs to have your full name. It needs to have the date. It needs to state that this is your final will and testament. It needs to say that you're of sound mind when you're writing it. And as I mentioned, depending on the state, it may need some witnesses. But again, in most states, you don't need that. All right, now let's start writing this out. Now at the top, we're just gonna write last will and testament. Then at the beginning, you're gonna say, I, insert your name, Matthew Sorensen, being of sound mind, do hereby make this last will and testament. Now, guys, I'm doing this on an iPad for demonstration purposes. You're not. You're writing this out on a piece of paper with a real pen, not one of these, okay? Also, this is gonna take longer than 5 minutes because I'm trying to explain it to you here, all right? But you should be able to crank through this in 5 minutes. Now, if you've had any other wills or other things where you specified who gets what, say, I revoke all prior wills. In fact, sometimes it's nice to just throw that in there anyways. All right, now the first thing we wanna identify is, are you married or single? Say that, I am married. 2, put your spouse's name. I'll throw mine in there. Then list your children. I have children. If you have no children, say, I have no children. If you have kids, you're gonna list who they are. Okay, I've got kids, I'm gonna list them. All right, next, you're gonna need to designate a executor. Okay, so you're gonna say, I hereby designate blank as my executor. All right, so as simple as that. Now, if you're married, you might wanna list your spouse as your executor upon your passing. Obviously, if they predecease you, you're gonna need to update this. Maybe it's one of your older kids or a close family member or friend that understands your estate and your family dynamics. But it could be one of the beneficiaries, okay? It doesn't have to be some third party. It doesn't have to be a lawyer or some other person like that. So we can list anyone we want as the executor. They just have to be an adult. So don't list a minor child or anything like that. That's not gonna work. Now, sometimes you might wanna list a backup executor. So maybe you list your spouse first and then maybe list one of your children, maybe the oldest as your backup executor. So you could list that out here too. That's just an optional thing to throw in. Now, when you list them, make sure you're clear who they are. A lot of people will say, I list John Smith, who lives in X city and X state, so it's clear who they are. Maybe that's your sister or your brother. Say that who they are when you list their name, so it's clear that this is the actual person you're intending. Now, the next section is the most important section of your will if you have minor children, and this is the guardian designation where you specify who will be the guardian of your kids upon your passing. Now, if they have another parent, that parent is generally gonna be the guardian automatically. Okay, this could be contested in the courts if that other parent was not fit to be their actual parent and guardian. But assuming that's the case, is typically gonna go to that other parent and guardian. But what if their parent is not around, or what if they are deceased? Who would you list? Okay, in that scenario, we may wanna list one of your siblings. Maybe this is a close family member or other friend that would be the guardian of your children. Obviously, a critical decision that this person is the right person. Okay, they may be raising your kids if you pass on too early. So let's specify who that is, because if you don't, a court's gonna decide for you after you've passed on. Now, if you're married with kids together, one of the easiest ways to say is, if my spouse does not survive me, I designate blank as my guardian. Maybe this is your sister or your brother or your mom or dad. This could be grandma, whoever, okay? Let's list that person out. And then again, it obviously clarifies if your spouse does not survive me. You could also say, if my child's other parent does not survive me, I designate blank as guardian. Now again, if this other parent is not fit, you may want to just list someone anyways. Now, this does go to court, okay? A judge is going to still decide this, but they take the wishes of the parent into account as they are designating guardianship, and they are looking at the best interest of the child. Now for me, I actually going to skip this area on mine because my kids are over 18. My youngest is 19, so I've got nothing to list here. I got step kids, but in my wife's will, she's designating and already has in her scenario who would be guardian. All right, now the next section here is what we call specific bequests. These are specific pieces of property you want someone to have. Maybe this is your guitar, this is your jewelry, this is the guns, okay, this is the Corvette, this is the Porsche, this is the boat you own with your friend, okay, whatever it is. If you have any specific items of property you want a specific person to get, this is where you list them. So I would say, I want, yeah. So for example, this is where you say, I want Johnny Martinez. Is that your last name? So this is, for example, where you would say, I want Johnny Martinez, you know, helps me with my YouTube, to get my Audi. Or for example, I want Angel Reyes to get my American Standard Fender Telecaster. That's a good get, okay? All right, we're not talking about the foreign Fenders, okay? This is the American Standard. These are my YouTube guys here, of course, in the room here. So I gotta make sure they get something out of this. And this is actually not legally binding because I'm doing it on an iPad, but so don't, you know, sorry guys. But seriously, this is an area where you designate the specific things and definitely things you may own jointly with another person. You wanna be clear who gets that. Maybe it's that other person, the brother you bought a boat with or something like that. They're gonna get that maybe when you pass away, I don't know. So specify any of those things or any special things that you might have you want a specific person to receive. A lot of people do seriously list out musical instruments, certain family keepsakes, jewelry, things like that. So specify those out here. It's a good opportunity to do it. Now, if you're like, man, I got too many things to think about and I want to do this well in 5 minutes, just skip this. List the things immediately on your mind and move on. This is not a full-blown estate plan, okay? This is the down and dirty will to make sure you clarify who gets what when you pass on. If you get hung up on this type of stuff, okay, you're doing it wrong. This is meant to be quick, down and dirty so you get something in place. The whole reason you don't have a whole freaking estate plan is because you haven't taken the time to do this and you're overthinking it, all right? So let's get this done. No, this is a good placeholder and thing to get done for most Americans. Most Americans don't even have a will. After this is done, then look at doing this the right way, think through it, have a very thoughtful plan, get a trust done, get the full estate plan done and taken care of. All right, let's get back to the down and dirty holographic will. Now, the next thing you want to say in here is all remaining assets after paying off my expenses and debts shall be sold, and the proceeds from the sale shall be used to pay any debts or taxes you might have under your estate. Then you're gonna say, I direct the residue of my assets and my estate to be distributed as follows. Now, if you have a spouse and you're listing that spouse to receive your estate, say that. Say, I direct 100% of my estate to go to my surviving spouse and list their name. Then you could say, if my spouse is not alive, I direct my estate to go to, and now we are gonna list maybe your 2 children who are gonna get 50-50. Okay, everybody's scenario here is different. So if you have a spouse and that person is gonna inherit your estate, specify that. If you don't have a spouse or your spouse has already predeceased you, maybe it's your kids and maybe they're getting equal shares, maybe they're getting unequal shares. Okay, I'm gonna come to that here in a second. If you don't have a spouse, you don't have kids, it's even more important that you specify who gets what, because the courts aren't gonna freaking know. And there's a presumption if you die without a will that your spouse inherits if you have a spouse. And if you don't have a spouse, then your kids inherit. And if you don't have a spouse or kids, they might look at your parents, they might look at your siblings. They're trying to figure out who's gonna get your stuff. So don't leave a cluster behind. Let's specify here who is gonna get what. But you can't have it conditional, okay? So I can say, I designate my spouse to receive 100% of the estate. If my spouse is not living at the time I pass away, then list who's gonna get your assets. And again, you could break that down by percentages amongst different people. So another way you can write this is simply, I designate blank to get 100% of my estate. List your spouse there if you have one, or whoever that person might be if you have a specific person. And then say, if they predecease me, then, and you can list the second takers that might take. And again, this could be under certain percentages as well. So let's specify that. This is a critical part, of course, and this is the point of this, is to clarify who gets your stuff when you die. If there are specific assets, you would have listed in the section below. Those are already done here. This is everything else. Okay, your executor is gonna go sell everything, and this is who's getting that cash and all the residue of your estate. All right, now the last piece here, which is critical, is I want you to add this clause that says, if any beneficiary listed above predeceases me, their share shall be distributed to their descendants per Stirpes. I'm going to explain what that means here in a second. Then right, if there are no decedents, their share shall be redistributed equally to the other surviving beneficiaries. Okay. All right, now let me explain what that section is doing right there. Let's say you had 3 kids, but before you died, one of the 3 kids had passed away. And in the will, you specified each kid gets 1/3 of your estate. Well, what if only your 2 are living when you pass away? What happens to the share, the 1/3 of your child who predeceased you, who died before you did? Who gets that? Well, when you say per Stirpes, as we talked about writing out here, what that means is that the heirs of your deceased child takes that 1/3 interest. That 1/3 interest doesn't go over to your other kids. It goes to maybe your grandkids, okay? It goes to the heirs of your deceased child, okay? That's what's happening there when you say per Stirpes. Now, if they don't have any heirs, they didn't have any other kids, they didn't have a spouse, nothing else, then it would go over to your other children who would take 50-50 in that example. But that's what that section is trying to protect there, is the per Stirpes designation, meaning it goes to the heirs of whoever was deceased before you were. All right, now we're almost done here, okay? You've hung in there. This is almost over, guys, I promise. What you want to specify here is, how do you want to be buried, and do you want a funeral, or what type of service do you want? Do you want to be cremated? Specify that. Here's an example of what you could say. I wish to be cremated. I request that my ashes be spread at XYZ location, the Pacific Ocean, whatever it might be. I ask for a celebration of life rather than a traditional funeral. Or I ask for a funeral at XYZ church with XYZ type service. This could be a military service for veterans, whatever it may be. Okay, you can specify that out here in the last section of your will. This section right here at the end is really more procedural than anything. If this takes you more than a minute to think about what you want, just stop and you can even skip it. But if you do have a quick idea about what you would want, let's write that down, get it designated. If you want to be buried, but you don't know where, that's okay. Just say I want to be buried and I let the executor or my loved ones choose that. That's fine. You can leave stuff like that in the will in a section like this. All right, now one last thought here you may want to include. If you do have pets, a lot of people need to be designating who is going to take care of their pet and who gets their pet upon their passing. You may even want to set aside a dollar amount for them to take care of your pet. This could be thousands or tens of thousands of dollars. I don't know the pet and the cost, what might be in your situation. So you may want to specify something like this. I leave Fido, my loyal and loving dog, to my friend so-and-so, and also designate that they receive $5,000 from my estate to care for my dog. Okay, so you could specify that here at the end. This could be really up in the specific bequest either, but just a little caveat there for any of you that have pets and you want to specify who will care for that pet upon your passing. All right, now we're at the end here and this is what you need to say, okay? All right, we're wrapping this up. This is right before you sign it. You're gonna write out, I declare that this is my last will and testament and that I am of sound mind and revoke all prior wills and declarations. We state that, we write it out, and then we sign it. It's in your name, and now you have a legally binding and enforceable will. Now remember, as I mentioned earlier, you might be in a state that requires some witnesses or even a notary. Again, most states accept a valid holographic will. You want to make sure you look that up in your state. This is not meant to be legal advice, by the way, here. This is not meant to be a substitute for legal advice. But too many people don't freaking get a will done, and they leave their family in shambles because they won't go talk to a lawyer. So let's get this done. Let's get it in place. Now you need to make sure that your loved ones know that you even have a will. The number one person that needs to know about this and where it is the person you listed as executor of your estate. This person's the one that's gonna have to carry this all out. So as executor of the estate, they need to know about it. Maybe this was your spouse, maybe this was your oldest child, maybe this was your close friend, whoever it may be. Make sure they know about this and even have a copy of it, or they at least know where this original is. Now they need to have access to the original for this to be binding. Now what happens when you pass away is your executor is gonna need to take this to probate court. If you don't wanna go to probate court and you don't want your estate probated, you need to go get a trust done, okay? That's what I talk about in the other videos that I mentioned earlier. You need a trust, and that's what I recommend for most people. But a lot of people don't go do that. In 5 minutes, you can get a holographic will here and specify who gets what. All right, now, what your executor is gonna do when they get through probate is a court's gonna say this is a valid will, and we give authority to the executor to carry out the wishes. There's something called letters testamentary, and there'll be an order from the court that that executor can use to go access bank accounts, to go transfer real property, to go sell sell assets, to title cars, whatever things might need to happen, they're gonna have authority to do that on your behalf after you've passed. All right, now lastly, as you're thinking about your stuff, keep in mind there are certain assets that pass upon what's called a payable upon death or beneficiary designation. This is bank accounts, this is investment accounts, this is retirement accounts. This does not pass according to the terms of a will. Those assets pass according to who is listed on the account to receive it when you die. So at your bank, at your brokerage, you need to make sure who is listed as the beneficiary is who you actually want. On your retirement accounts, same thing. You may need to update and check your beneficiary designations. So that's a good tip right now. If you're not sure, you need to go look at who you listed, and maybe you didn't list anyone at all, and that's bad too. So those assets are not going to pass through the will. Those assets pass through who is listed on the beneficiary designation itself, and that beneficiary designation controls and is enforceable over the will. All right, so go check those designations. That would include your life insurance as well. All right, well, I hope you got through this and you have a valid and enforceable will. And if you're like, Matt, I have so many questions about this. I got a lot of questions about my estate and my assets and what happens. Are there taxes? How does probate work? I got stuff in multiple states. I got kids from another marriage and kids from a new marriage. I mean, you need a consult with a lawyer. Go find a good one in your state. If you don't, my law firm, KQS Lawyers, we help clients across the country plan for and get their estates done. We get the assets in them so that they're funded. And we talk through a lot of ideas and strategies that you can do so you leave a legacy and not a burden behind to your family when you pass on. Now, the last thing I want you to do before you die is subscribe to my YouTube channel. If you haven't subscribed yet, what are you doing? You need to subscribe to my channel. I've got a lot of tips on protecting your assets, saving taxes, and building wealth. I'm Matt Sorensen. We'll see you next time.